it's great. It's a moment of great pride for me to be able to introduce you to 5 of the 6, I should say 7 women authors who've contributed to the 24 chapters of the book. And I'm going to start on the far side with Ghislaine Lovejoy, who's written the chapter on contribution agreements. And then I'm going to go to Kate Stewart, who's written about supply chain and SPDX. Nithya Ruff, who's written about OSPOs, open source program offices. Pamela Chestick, who's written about trademarks. And Karen Sandler, who's written about foundations. And each and every one of those women could stand and hold a keynote at this conference and would be very well respected for it. So this is going to be one of the few occasions, I think, that you see as senior a panel as this, particularly on the policy and legal side of open source, anywhere in the world at any point in time. We will be doing more of these panels, and we will be doing more book giveaways for the next 12 months. But, I'm very proud of you, team. And I'm going to let you start introducing yourselves with Ghislaine first.
Thanks. My name's Kate Stewart. I work at the Linux Foundation with mostly a focus on embedded systems. And that's been a bit of an arc for my career up till now, and that's part of the reason I got interested in software bill of materials and how we can actually share the information, because I was putting out a BSP a long time ago when I was at a hardware company, and we really had no way of sharing information. And so making sure that when we were using it and shipping Linux and various other open source projects, we could actually summarize the information and comply with the licenses, and then not have to do the same work that my colleagues at Monte Vista were doing, my colleagues at Wind River were doing, and everyone else was sort of the inception of it. So how we can share things effectively and efficiently through the open source ecosystem is part of why I've been focusing on this area for a while now.
Thanks, Kate. I'm Nithya Ruff, and I lead the open source program office team at Amazon. And the open source program office chapter, which is chapter 19, was something that I was so excited to write, because this is the 3rd open source program office that I'm happy to lead. And this is a construct that's becoming very, very instrumental in driving strategy and driving engagement and driving intentional open source work across many institutions, whether it's companies, government, or academia. So that's the part that I'm happy to contribute.
So before I introduce myself, I just want to say that I was just fascinated with that thought, because I've only thought of OSPOs as being compliance, and it never occurred to me that they're strategy. So I'm like, mind blown. Okay. I'm Pamela Chestick, and I have a legal practice at Chestick Legal. I live here in Raleigh, North Carolina. I'm a trademark and copyright lawyer and working in the open source field. Started at Red Hat. I was the trademark attorney for Red Hat, and when I left there, I started my own practice. So I have a number of clients, both proprietary and open source software, that I do trademark work for, and wrote a chapter on trademarks.
Hey there, everybody. I'm Karen Sandler. I'm the executive director of the Software Freedom Conservancy. You'll see me wearing a mask because I have a heart condition and I have an implanted pacemaker defibrillator, and I can't see the source code in my own body. And that journey, well, who else but a Karen would ask to see the source code in her own defibrillator, right? And so my connection with this field is very personal, because I'm more interested, or I'm very interested in how our technology impacts the public and impacts people. And so Software Freedom Conservancy is about that intersection where we stand up for user rights and the right to repair our software, in addition to creating alternatives to proprietary software so that we actually have something we can use, and also promoting diversity and inclusion. We run Outreachy, which is a paid remote internship, and so check that out if you're in that space right now. So I'm also a lecturer in law at Columbia Law School, and my chapter was on foundations.
So we're now all using one mic, which is not entirely COVID friendly, but there we go. I've got all these questions here, and there's a first one that I'm going to field for the team, which is, will there be an abridged version and summaries? Now, if anybody as a community would like to help collaborate to create those, you're going to have to read the chapters first, obviously, to do that. And maybe we could talk the authors in at some point to writing it. There was one author who gave me 25,000 words when the cap is 15,000 a chapter. So, you know, everybody has a lot to say about their subject, and there's a lot of information and important information. The index, which I put 100 comments into, in the first round and more in the second should be helpful. So hopefully that will be a good way for people to dip in and out, find the topics they want. But no abridged version planned, but we are doing a podcast, and we have already recorded the first of those with Nithya, talking a bit about the chapters, and we will push one out a week for the next 24 weeks for each chapter. The team who's here today, they'll be the first 5 guests on the podcast, so that will give you some of the key information from it. We're trying to pick out some headline topics there. And going to the topics, there are so many good questions here, but some of them are quite hard. And I'm moving. So, any thoughts on how open source is being perceived or practiced in China? Does anybody want to put their hand up and answer that one? It might be easier because I've got the mic for you to put your hands up, and I'll bring it to you. So the only thing I know, I'm going to not keep answering questions, but the only thing I know about that is it MIIT or MIAE, the Chinese Business Authority. They put a thing out towards the end of 2020, which specifically calls for a focus on open source and developing more communities within China. So there's a keen understanding there that they need more open source software. Then there is a question about CLAs, Jelaine. What's your recommendation on why one would use a CLA versus a DCO for open source software project? And I'm not going to comment. Under any circumstances, I'm not going to talk about CLAs.
Well, naturally, I have to start with I'm a lawyer, but I'm not your lawyer. And actually, I think that isn't really a question I can really answer, because it depends on what your goals are. And so, I would say sort of my sort of safe lawyer answer would be, there should be and I say this in the chapter, you should have a very real conversation about if you're assuming you're starting a new project, about what your goals are, and if the idea of a CLA is on the table, which usually comes from someone in a legal department who may or may not have a good understanding of open source community. They may know about open source licenses. Sometimes it comes from non-lawyers. I think there's a lot of assumptions and I don't know, sort of hand-wavy reasons that people have CLAs. When I say CLA, let's just be clear. The chapter I wrote is called Contributor Agreements. That was as broad as I could come up with. I'm not a good title kind of person. And what I mean by that is whatever the agreement is that governs the contributions into the project. And hopefully everyone here is well aware that the most common model for that is what's referred to as inbound, outbound, meaning that the contributions go in under the same license that you receive the code under, which is obviously the easiest to understand. So, I think there's valid reasons for using a CLA. My argument is that it should be a valid reason. It creates a lot of overhead. And I've seen, I always knew that and I always heard people talk about that. And then I had like my own firsthand experience at a company where I inherited the CLA they'd been using, and there was this other level of overhead that I hadn't really thought about. That was just, and then it made us all question why do we need this? Why was it implemented to begin with, and do we still need it? And I was very happy to be part of a push to say let's just stop using it, because this maybe that seemed right then, but it's not now. So those things can also change. My personal opinion, again, not anyone's lawyer, is that if you can do inbound, outbound, that is preferred. It is most easy for developers to understand. It's more egalitarian, it's more collaborative, and if that's what your goal is, then that is going to be the easiest thing. But depends. Yep.
CLAs.
Can I add to the China?
I was just about to say, I think Karen wants to answer something. Can we come back to China in a minute? Because there's another policy question coming up. So, obviously, I agree with Jelaine. My first experience was seeing licenses called assignments and assignment called licenses. And I think the whole area is very confused. So using something that is straightforward, recognized and standard in the way our licenses are standard really helps. So Karen, we have a question about the state of enforcement. Now, it doesn't specify enforcement of what. I assume it means licensing. But I'm going to ask you to answer it, and then that could be a whole talk, I know, but then I'm going to ask you to pass the mic to Pam and ask Pam about the state of enforcement around trademarks. So if I can hand over to you.
Sure. I mean, I think we can't talk about the state of enforcement without talking about the state of compliance, which is just, I would say, astoundingly terrible. We at Software Freedom Conservancy get so many reports every day that we simply cannot keep up with them and investigate them all. And so we at Software Freedom Conservancy follow up on as many as we can, and try to follow up on as many of them using our principles of community-oriented GPL enforcement. But there comes a point where being nice and asking nicely no longer works. And so we bring lawsuits as a last resort. We filed a lawsuit against Vizio, the television manufacturer, in November. And it was a consumer rights action where we filed as a purchaser of televisions, which is, I think, the first time that there's been a suit.
Whilst you're on that, we have a
Yeah.
specific question about that. And right
Oh,
to
a specific
repair.
question about Vizio and...
It doesn't name Vizio.
Okay, right to repair.
And where we are with that. So maybe you want to pick that one up.
Sure. The question is about right to repair and where we are with that. And the two are very connected because copyleft licensing is some of the most amazing unused mechanisms we have for corporate accountability as a consuming public. There are millions of devices with copylefted code on them, and that grants users rights, rights that have not been widely exercised in ways that could create quite a lot of collective action as a society. So I think there's so much promise there, and people are just starting to really understand that we as a public can take control of our devices, that we can work together and replace the software on our devices, and that we have this whole exciting world available to us. And copyleft licenses are the way that we can connect those dots. And so we're demonstrating that through this suit and through other action. And so I think that we're going to see a lot more than that. People are introducing laws in different jurisdictions about right to repair. I think we'll see a lot on that, and there's a lot more to come from Software Freedom Conservancy. So I think there'll be some exciting things soon. So I'm going to pass on to Pam for. Oh,
You are going to pass on to Pam, but just before you do that, because we've only got one mic and I can't stop you. Sorry, I can't interact with you, which is difficult. There's in the book, the question actually asked, are there any scholarly treatises on it? And Karen wrote about foundations. Ian Mitchell Casey, which used to be QC, King's Council, has written a chapter on the public sector, which has quite a lot about right to repair in detail across the different jurisdictions. So he does a lot in Europe as well as the US. So I just wanted to share that. Pamela.
So enforcement and trademarks. One thing that I say about trademarks and open source is the law is exactly the same, and actually the interests are exactly the same as the rest of the world, which is this sort of, somebody standing behind the product. Who is the person standing behind the product? What is different about trademarks and open source is the audience for those trademarks. So it's more sort of, you don't send out nasty cease and desist letters. You approach them sort of the same way that happens with copyright enforcement, as we try to take a collaborative approach to it. We are starting to see, for many years, I would say there were no lawsuits about open source trademarks. There are now a few lawsuits. And I think the reason is, as with many industries, when an industry is small and it's very friendly and everybody knows each other, then there's not litigation. But open source has reached a point now where it's kind of huge, and many commercial companies rely on it. Many use it as a marketing tool. And so we're starting to see lawsuits around the names of open source projects. So again, it's kind of, we see from copyright enforcement that a lot of these copyright enforcement lawsuits are between commercial companies. They really don't care about the open source software. They're using it for leverage for some other goal that they have. And so I think that the same thing might be happening in trademark lawsuits. Is it's not about the trademark per se. It's about getting commercial leverage against one of your competitors. So we're seeing, and frankly, open source projects don't have money to bring lawsuits. The people who can bring lawsuits are the commercial players who can fund it. But I work with projects, and I talk to them. Sort of, what is your viewpoint on enforcement? What do you consider okay to use? What is not okay to use? And there are different viewpoints within projects. Some have a high level, low tolerance for infringement. Some have a very high level for very high tolerance for infringement. So it's very unique to each project.
So there's a couple of questions around policy, and I'm going to come to Kate on the first one, where they're asking about policy and the US government and supply chain. And Ghislaine has already mentioned SPDX, which I think Ghislaine and I were in a bar in Boston around 13, 14 years ago when the SPDX as a concept was created by a couple of people from Motorola who are no longer really part of this open source community. And you in the bar as well? I don't remember you being in the bar. No, I didn't think you'd been in the bar, but SPDX was something that's really Kate's baby. And I was worried I didn't remember you being in the bar. Anyway, I'm going to hand over the mic to Kate to start to talk about that. And the question is around supply chain and US government, and can we discuss more how the US government is taking an approach to supply chain? I may come back with some other points on that, Kate. Then we have some questions about the differences between the US and Europe that we'll pick up on.
Well, there's been work defining what a term SBOM actually means for the last few years, and NTIA has took the start of that and worked on getting those definitions in place, and then managed to get work with it's the Department of Commerce for the U.S. government, and they worked with the Biden administration to get an executive order out, and in there I think there's about 11 mentions of SBOM. But they're not the first ones. There's also been mentions out of Europe about SBOMs. And so there's a growing recognition we need transparency in the supply chain, and we need to be able to say what is actually there. And what you need to understand for licensing and the relationships between software components, you need to understand for security and vulnerabilities. If you don't know what your dependencies are and what you're depending on, you can't say whether or not you're compliant with the license, for one thing, but you also can't say whether or not, if there's a vulnerability in this component, will it affect the product you're shipping, and do I need to take remediation and action? So policy is, the policy aspect is you're seeing more and more people using the power of the government purse to influence industry in order to comply. And so what came out of that executive order was saying, if you're working with the GSA here in the US, you're going to need to provide an SBOM, which means you're going to have to at least have a very minimum set of it. There's a lot more stuff we should be including, but it's heading in that direction, and people are refining it, and security is motivating it to a large extent.
So Kate has a survey question that shows over 70% of US companies claim to be using SBOMs now. We did a similar question in the UK where there's no legislation, and we got just over 20%. So it does seem to be having an impact and a marked difference. But Kate, or to the whole panel actually, do you think SBOMs and this focus on supply chain is good for the open source community?
Yes. If you can't, like I say, if you don't know what's there, you don't know, and improving the transparency on what's there is going to then, quite frankly, improve the transparency on the licensing as well, such that compliance is possible. And I see Karen making noises, so.
I don't think it's bad. I think it's good. I just think it's like we sometimes use the analogy of it's like sometimes like getting a list of parts in your car but not knowing how they're put together. It doesn't mean you can fix your car or even do basic repair, right? So like there's just limited utility with SBOMs, and I think that some folks are proposing that it sort of focusing on SBOMs is the end all be all. And while it's important, it's a step. And really what we need is our complete and corresponding source code. Like what we need is our source code to be able to do something with it.
I will agree that it's not the end all. SBOMs are not the silver bullet, but they are a step, and we have to start somewhere. And we haven't been there till now.
Yeah, I would just echo that. I think there was a conference I was at a long time ago, because I haven't been to one in a while, someone quoted me saying, the list is not compliance, which to me a list is SBOM, BOM, whatever you want to call it. People get obsessed with these different terminology. But to Kate's point, I mean, you can't start to think about the corresponding source code until you even know it's there. And surprisingly, as many years as I've been in this field and started a company that did work around helping people figure out what they were using. People still don't really know what they're using. So I think that is, like you got to start somewhere, but it's not the end either.
So I'm going to take it back because we're going to get onto other topics in a minute. But with S-bombs, there's a lot more to say. There's going to be a lot more to say in every topic. With S-bombs, one of the things is it is a partial solution. It is not ever intended to be the whole solution. And I think we're seeing a lot of different solutions coming out around security, around curation, this emerging term, looking at technical hygiene and legal compliance and governance. And what I want to emphasize, and I'm sure Karen is going to be agreeing with me based on what she just said, is that the obligation for that compliance sits with the user. It does not sit with the developer or the engineer. And I suspect that the question asking us about, is this good for communities, is thinking about that additional burden being put on the developer. And in terms of the next question about the difference between EU and US laws, and is there still a friction and a difference between the two, I was at a conference maybe a month ago and I met the director who is implementing the Cyber Act, which in Europe is where the equivalent of the S-bombs under the Biden ordinance comes from. And in discussing it with her, they've done something where they define commercial open source, which doesn't work. So they're looking at taking that out. And they have lifted and shifted what was in the US. So it should be very similar and it should interoperate. In the UK, we have no position. Brexit's taken a toll on all of us, and we're a couple of years behind, but we will have a position soon, I'm told. But currently we have none. Obviously, I'm trying to help them find their position. But I agree with Karen that we really have to focus also on the fact that the engineers, the developers, the contributors to our communities can only take on so much burden, and that we need international governments and public sector to be providing not just money but resource. So on that question of the Europe and the US, does anybody have any sense that they want to jump in with on the differences? And I know, Karen, you wanted to bring back that question about China when we're talking about policy.
Oh, no, I was actually just going to recommend that folks watch Naomi Wu, who bills herself as Sexy Cyborg, has this amazing video where she goes into, she's in China, and she goes into a company and asks to get the source code for GPL code. And it's amazing. Check it out.
Okay, anybody else want to jump in on policy? Right, so, yep, okay, Kate.
So I'll also sort of bring into the mix the Japanese, and they tend to be aligned. So there's actually a lot of work collaborating between the governments and sharing discussion and information, at least on in the cybersecurity side of it, to help try to build some consensus and build things. Because quite frankly, open source is international, and so we need these solutions to work internationally.
I completely agree, and we've just hosted an event on the 17th of October in London, which will be part of the Open UK Summer of Open Source Software Security, openuk.uk/security, where you will see the videos from that. I think they've been put up today. And we're planning an event for 1,000+ people in London next spring that will specifically try and address that and start to bring people together to talk internationally about it. But Nithya, you've been very quiet, and that's not like you. So let's go back to OSPOs and think about OSPOs and where this fits. And we have a question here about companies being too open. Is there such a thing? I don't know the answer. I think the answer to this question is simple, but have you ever seen shareholders take legal action against a company's management for being too open? Too open with their code or other IP that shareholders felt should, what does that say? I haven't got my specs, stay for pay. Yeah, so basically they're saying, are they giving away their crown jewels, and should they be, and is this a problem for shareholders? Which of course is taking us to shareholder value and how you measure companies, right?
I don't recall any such legal action, but I don't actually go looking for such things. So all I can say is I think companies are more and more looking at all of the work that they do and realize that so much of it can be shared and can enrich downstream communities of customers and other folks who want to use the production grade and high scale work that companies do. We test use cases that hardly any project gets to test. When we are testing at millions of people and millions of bytes of data and so on and so forth. So I think more and more companies are becoming more open, which I like. But I haven't seen any kind of lawsuit against this. I did do a talk a few years ago about why the boards should care about open source in their companies and make sure that they have an open source strategy and that they are taking care of the risk side of open source as just as much as the opportunity side, the opportunity to build ecosystems, to create standards, to collaborate with their customers and partners. So I think boards should absolutely care about open source, but not that their companies are too open.
And just sticking with that, you talked about risk there, and you would expect the lawyers who'd contributed to the book, not the OSPO people, to be talking about risk. But I think we've seen a shift, and the shift we've seen is that 15 years ago when I joined Canonical, it was a nightmare. It was an absolute nightmare, and it was a nightmare because we were negotiating contracts with people who didn't understand open source. And it would go on for months, sometimes years, before you would get those contracts over the line. And it would be their procurement people, their legal people, maybe their finance people, and they were a complete blocker, and they just didn't get it. So, you know, we did different things to try and educate and help, but actually that's no longer necessary. And it's no longer necessary because of the cultural shift around. Well, you're one of them. I'm not going to take it to you. It's no longer... It's no longer as bad, and risk has shifted to an extent because you just go and take the code now, right? You just go to GitHub, GitLab, wherever it is. You go and bring the code into your company. You don't have to go through legal, procurement, finance to get approval before you do it. But what you hope is a smart company will have shifted and it will have started to look at its policies and its procedures. And that's something that has moved in many ways, or to a large extent, from the legal and compliance people over to the OSPO people. So I know Pam wants to jump in, but I'm going to go back to Nithya first.
I think that is a really good use case for having an open source program office, whether in a company or in the government, like the WHO, etc., or in an institution, because not everyone needs to be an expert at open source compliance or law or community. And if you have a group of experts who own doing that, as well as elevating the knowledge of the rest of the company and reducing friction for developers across the company, then you do it with intention, with focus, with some policies and practices put together. That's one of the big roles, I think, of an open source program office, is to create expertise and intention around how we do open source. And the strategy side of OSPO is that understanding when to engage, how to engage, which communities to engage, how to navigate community, both upstream and downstream, when to release something that we create as open source, when to collaborate with an open source foundation or an organization, are all big questions that we participate in along with other experts in the company. And I'm passing it on to Pam.
Yeah, so I was going to pick up kind of, Amanda, on what Amanda was talking about, and also about your chapter. I was going to agree with you that I think about 20 years ago, then the only business model that people could think of with software was to enforce the copyright. They're going to license the copyright and make money based on royalty payments for the copyright. That's the Microsoft model. That's the Apple model. I agree that in the past, I would say, maybe 3, 4, 5 years, I am seeing more companies who are getting much more nuanced and thoughtful in what their business model is and about using open source. So it was so hard. It was very hard sometimes to get people to even sort of think creatively about what are other ways you can make money besides getting a royalty payment for your copyright. Throw that away. How else can you make money? And so I see a lot more sophistication around business models that people are coming up with and understanding the true value of what it is that they're creating and how the software and how open source software fits into that model. So it's sort of, I mean, it's a little flip on the question, which is, you know, maybe not loss of value, but really it's just a I hate to use the word paradigm because it's, you know, so hokey, but it is a new paradigm on how to create revenue from software that is not royalty based.
So just coming back to that, it actually aligns really well with one of the questions around business models and shift. And of course, we all saw Elastic doubling down on open not. And shifts to licenses like the SSPL, use of things like the Commons Clause, which undermine open source. And they focus us a bit on education, I think, and understanding that open source is more than just making source code freely available and putting it on an OSI license. But that question about the OSI license is super, super important. And one of the questions we have here is, well, there's two questions that I think are going to be interesting to you, Pam, and to the others. One is, are there any specific, what word did they use? Unusual, I think it was, licenses that we want to talk about. And then also, if we have any recommendations for someone who is the victim, where they've been using open source software, but the next version's moved to being proprietary. So who's going to jump into that one first? Come on, into the lion's den. There you go, Karen.
Well, it's easy for me because because I'll just say if you make smart license choices at the beginning, in particular choosing strong copied left licenses, you are much less likely to be in a situation where your code is proprietarized. So there's a goodness there, not just for the individual developers, but also for the communities that rely on that software and for businesses overall.
Oh, I've got a comment on the, I'll also say that having a distributed set of contributors will stop these things going proprietary, and this is sort of one of those things that the Linux kernel has in terms of with the DCO for copy left, but they're using the DCO and they're basically having a very distributed copyright regime, and that tends to reduce risk.
Well, thank you both for the nice cue up to back to my chapter. Yes. So I just, it sounds like a silly reminder, but every time you see, or this is what I think, of course I'm a lawyer, every time you see a project change its license to something non or less free, I think to myself, well, I guess they had a contributor license agreement, because to Kate's point, if the copyright, if it had been inbound, outbound, right, and which means then the copyright is distributed among all the contributors, it's not impossible, but it's much harder to just, you can't just turn on a dime. You have to get everyone's permission to change, right? So it's really important, we talk about open source licensing in various ways, but understanding some of the basic tenets of copyright and how it works is which is of course copyleft to play on, is a really important thing. And so I always think, every time I see one of these licenses flip like that, I just think, when is some contributor going to figure out that like they contributed and didn't sign a CLA and kind of make a ruckus? But I mean, it's on the flip side, if you're contributing and you have to sign a CLA, I think it's right to ask kind of like, why are you needing this? Because that's usually why.
So it's definitely not the best written chapter in the book, but chapter 16 is mine, and it's about commercial and revenue models. And in that chapter, I go back to 2008 when the first report was done on commercialization of open source, and there's 8 basic categories of models, and I don't think they've changed. There are unique and creative ways of doing it, but they all still fit within that. And to my mind, it's inexcusable today to be releasing, I don't say this in the book, but it is what I think. It's inexcusable to be releasing code as open source and not understanding what that means. So if you're a founder, you need to understand before you do it. And if you haven't got the business model to support it, you shouldn't do it. If you're releasing that code in order that you generate money, and you need to really understand that open source is not a business model. It's all sorts of different things to different people, but it is definitely not a business model. Do I want to say anything else on that? I tried not to have my views come through in the book chapter, which is why it doesn't say it quite as strongly. And what I tried to do was create a survey of what was really going on. But there have been a few other points in this discussion that I think we should pick up on. One being projects that have single company contributions, and projects that are, I suppose you would say, single vendor products where they're not supported by other people. And I think those are real issues. And if you're looking at adopting open source as an enterprise, or you're looking at what to adopt, and whether you're public sector or enterprise, in fact, you should really be considering who it is that's contributing and how good the contributors are. And I think, Nithya, you've probably got something to add around contributions.
I completely agree. When you're looking at what to consume, it's not just what is the license, but how diverse is the community. Sometimes, projects backed by foundations can be healthier because they have a set of rigor, whether it's the Apache Foundation or the LF or others. So that's important. And then on the flip side, I think contributing back is so important. So one of the things that an OSPO often drives inside a company is that consciousness that we need to give back, not just take, whether it is because it's good for us from a technical debt perspective, or because we want to make sure that what we're depending upon is sustained and secure and healthy, or because we have something to give and we have some value to add back to the community, whether it's in the form of money or code or evangelization or volunteering our time and expertise, etc. So that's one of the big things that my team and I and other stakeholders that I work with inside the company try to drive, is to make sure that we are full participants in open source.
So I'll point out that the Linux kernel is still getting about 9 commits an hour. Okay?
Wow.
And that is a community project. I don't know of any project that's run by a single company or that's controlled strongly by one company that has that type of rate of contribution. And so being able to see that contribution and all those ideas flow and be effectively synthesized together into a useful entity is why communities tend to work when they're structured right. Zephyr is one of the ones I've been working with very closely. It's up to 2 commits an hour. And there's a whole bunch of commercial RTOSs out there that are like, 1 commit a week. So.
Yeah, we're getting towards the end of our time. In fact, we're over, but we started late, so I'm going to keep going for just a few minutes more. There's a question here about copyleft, and the question is that don't you put your company's IP at risk by using copyleft? And I think that depends on which side of the fence you're on. If you are bringing code into your organization and it's copyleft, there is a traditional fear of viral effect of copyleft. If you're distributing on copyleft, you then require others to contribute back. And that's a very different basis of a business model. And I'm going to let Karen comment on that. But also, I would recommend anything written by Frank Karlashek. He's done a lot of talks about it, and he is really good at explaining why copyleft is good for business.
Oh, I love that. And I could go on, but I think actually hearing from people who are more, who are in the practice of advising business might be a better, what do you tell your clients, Pam?
Yeah. So this is when I'm having conversations with business clients. It is about, and I think copyleft doesn't get enough attention for the reasons that I think everybody in the room seems to understand, and the panel seems to understand, is it does prevent this commercial, this proprietization of software code. Frankly, I think that was when I saw the Elastic project first emerge and saw it had the Apache license, I was like, well, there you go. I mean, it was that was writing on the wall was going to happen with Elastic and the Apache license. So I do always educate my clients about copyleft and the value of copyleft, and does it fit into sort of back to what is their business model, what is it, how are they intending to make money off their project, and explain to them the value that copyleft may have in assisting them in their business model, because it will prevent others from taking their code and using it in an exclusive way and in a way that excludes them. So I think it's an important, I think businesses underrate the value and strength that they can achieve by using copyleft.
So we're right at the end of time, even using our extra 10 minutes. I'm conscious that probably like me, not everybody could find the app or get into it and do what they needed to do. So just to wrap up, I'm going to try and take a couple of quick questions. I appreciate there are other speakers who want to be up here doing their session after hours. Is there anybody in the room who has another question or two that they want to ask the panel? I mean, it's free legal advice from some of them. I would take it if you can get it. Stephen. Yeah. So that question, sorry. Hold on. Yeah. So this question is really about CLAs and how they're framed. So some CLAs, some contributor license agreements, give you a very wide license that allows you as a project to change the project license over time. They may even give an exclusive license in some cases, and that allows projects to change licensing. However, a more lightweight CLA wouldn't allow that, and it's really asking about for some commentary on those changes. And I think it's something that Jolane's chapter actually draws out a bit, the kind of terms that you have in those. But if we can keep it quick so we can ask one more.
I mean, obviously, it depends is the answer. But I mean, I think the important point is that unlike open source licenses generally where, say, BSD and 3-clause and Apache and GPL, like we know what they look like, we're very familiar with them, we see them, we don't read them again, probably should, to be honest, but CLAs are not standardized at all. And one of a great, just quick example is the Apache Foundation has a very famous CLA. A lot of CLAs look like it because people copy it, and then it's not the same. So I think the best piece of advice I would say is read the fine print, and then think about how much you care about your contributions and what might happen based on what you read, because they're just not standard, and you never know what's like 3 clauses down.
And it's a definite case for license in equals license out. So if you're concerned about that, using that in the DCO, the Developer Certificate of Originality, is a good way of making sure that doesn't happen to you. Is there a final question? Yes.
Probably for Pam and maybe Karen, there was a lot of talk of, I don't know, 18 months or so ago about kind of lighter weight governance that was maybe more focused on things like trademarks, for example, and and obviously software critical services is done, sort of a lighter weight governance model. Can you get a comment about sort of what trends you see going on there?
Okay, so the very quick wrap-up question is, can you comment on any trends towards a more lightweight version of governance? And I'm going to let that go along the whole panel and back to me to end the session.
Yes, trends towards lightweight government, but also trends against thinking deeply about governance. So I think what we're seeing is people adopting governance willy-nilly, it not being very careful, folks attaching themselves to organizations where they're not thinking about the ways in which people are coming together to collaborate, and that needs to be a really significant thought process. And so in my section on foundations, I mean, one of the things that I really talk about is that it really matters the forms in which people choose to collaborate with each other. And so there are some really nice lightweight solutions, and sometimes they work for all different kinds of situations, provided that the ways in which we collaborate together make sense, and that the interests are clear, and that interests that are in opposition to the goals of the community are kept explicitly at bay.
I'll just say quickly that sort of in my engagement with various foundations, they have different models, and I think there's you should kind of shop around, because there are some foundations that do have a very lightweight sort of oversight, and maybe all they're doing is owning the trademark, and the project has a lot more kind of, I don't want to say freedom, but maybe less formalities around what they're doing. But I think it really is a matter of finding the right fit. A foundation, foundations is one way for self-organization, and I think that's it would behoove someone to explore several of them to kind of see what their management particulars are.
So I'm not going to talk about governance, but I'm going to give a final takeaway from Chapter 19, which is you can be of any size as an organization and still have somewhat of an OSPO. You can have one person, half person dedicated to thinking about how you want to engage with open source as an organization. So it's well worth investing and having that person as an ombudsman, if you will, for the rest of the world to engage with you on as well.
In terms of the lightweight governance, I'm seeing projects that are adopting the DCO and making it very easy for developers to contribute under which license, actually taking off and having a much stronger community engagement. So the less barriers we put in front of developers and the more fair we make it, I think the better it works for everyone, and that's where we see engagement.
Well, just as slight contrast, the governance is something that's come up in my head with a few of these comments, and a little bit of a takeoff on the lighter weight but not thinking deeply. I gave a talk a long time ago called Open Source Knowledge A Little Does Not Go a Long Way, and I think that still holds true. I think we are in this day where a lot of people think they know what open source is, or open source software is, or open source way. We have a whole new generation, and what they think it is or what it means at whatever level community project is not necessarily whatever you're thinking. And so I just think it is, if you work in this space, it is a lifelong dedication to education.
I think that's a good sentence to end on. It's a lifelong dedication to education, and we hope this book will contribute to that education.